Patrick Stegall. I'm a DUI attorney in the Memphis area. Today I want to talk about preliminary hearings in DUI cases. What's a preliminary hearing? How do these things work? A preliminary hearing, now under Tennessee law, you can have one on any kind of case, any kind of misdemeanor or felony charge, okay? A preliminary hearing is held in the early stages of the case. It's not a trial. It's not guilt or innocence. You're not winning or losing. It's simply to determine probable cause. Does the state, the government, or the prosecution have probable cause to carry this case forward to the grand jury? All right. So a preliminary hearing is not the full trial. Not every witness is going to be called into court. The government only has to put on just enough proof to show the judge that these charges can continue on to the next level. And that's true, again, of any type of case, whether felony or misdemeanor. Now, DUIs, I want to talk about that in particular. DUI, most DUI charges in Tennessee are going to be of the misdemeanor variety, okay? And should you have a preliminary hearing on your DUI, this is what I tell all clients. Only have a preliminary hearing if you think there might be a chance that it goes to trial, that it goes to actual jury trial. And I'll be honest, very few cases go that far. Very few DUIs go that far. That is your right. It's always your right to have that preliminary hearing. The benefits of a preliminary hearing are to get the witnesses into court and kind of get a look at them early on, because they have to testify under oath. They're cross-examined by me, so you get that testimony, it's recorded. So again, if you're going to trial a year later, you've got their testimony already, and if they say something different at trial than what they said before, then they can be cross-examined on that. And it's a good way to get an idea, get a kind of a sneak preview, kind of a free shot at the evidence that's against you. So that's the purpose of having a preliminary hearing. On a DUI, I mean, again, if whether it's a first offense or second offense, you know, if you're thinking about having a trial, like actually going to trial, then you should have your preliminary hearing, and that's the whole purpose of it. Okay, again, it's not to win or lose. It's just to gather evidence. You know, if you're facing if you feel you're absolutely innocent of this charge, and you're not willing to take an offer, and the government, the prosecutor is seeking to put you in jail for 48 hours and put you on probation and suspend your license for a year, then yeah, have your preliminary hearing. But understand that is the first step of a very long road. If you're facing a second offense, the stakes are higher, because there you're looking at 45 days in jail. If you're a commercial driver, that might be where you really have the most to lose. If you're a commercial driver, if you hold a commercial driver's license, a DUI is bad news, okay? You're going to lose your license, you're going to lose your work, your livelihood, if you get convicted of that. So you stand to lose the most if you are a CDL holder, and you may want to have that preliminary hearing to kind of lay the groundwork to actually go to trial. But again, it's a long road. So that's kind of how they work. There are some kind of strategic and tactical issues that need to be examined in each case also if you're going to have a preliminary hearing. I mean, my approach is I really don't want to win the preliminary hearing to get it dismissed, because you can get it dismissed if it's a lack of probable cause. If the judge finds there's not enough, and by the way, probable cause is a very low standard, lowest standard we have in the law. But if the government doesn't meet that burden at the preliminary hearing, the judge will throw it out. Great news, right? No, because the state can pick it back up, and you go back to court all over again. So there are some reasons not to have it dismissed, and to simply gather evidence and get them to testify and get cross-examined under oath. That's kind of how they work. Mississippi, I'll talk a little bit about that. What I was just talking about there focuses on Tennessee law. Mississippi, you don't really have preliminary hearings on DUI. You just have a trial. You just have a bench trial in the city court, okay? Because under Mississippi law, you don't get a jury trial on a first DUI, actually. You don't get to have a jury trial on a first DUI. You have your bench trial in front of the judge. Now, if you lose that, you can appeal it. You get a do-over, basically. If it's a second offense DUI, you can have your jury trial. So you don't really get too many DUI preliminary hearings in Mississippi. You could if it's a felony type case, but that's different. That difference between preliminary hearing and trial are not there. Those are not the same thing. So if you're facing a DUI in Mississippi and you don't want to take the deal, just have your trial. Just have your trial in the city court. Get the officer and any other witnesses in, and if you lose, you can appeal it, get a do-over in front of a new judge in a new court. Okay, but that's how they work. If you've got a DUI charge, give me a call. Thanks for watching.